Right, good morning everybody, and welcome to this session. It's good to see so many of you. This session is devoted to three very important Supreme Court decisions which came out this year dealing with fiduciary obligations. And the cases are Rucadzi, Hotel Portfolio and Hopcraft. And we're going to focus on aspects which are of relevance to professional liability practitioners.
Yes, I became involved in Jackson & Powell on professional negligence, as it was then in the early 1990s, rather a long time ago. I was about 13 at the time. And we changed its name in 2007 with the 6th edition to Jackson & Powell on professional liability, the year David took Silk. And I did actually have another look at the 3rd edition recently. I don't think I mentioned fiduciary duties once in my solicitors chapter. Life has moved on. And one of the main reasons for changing the name was because equitable principles, particularly for solicitors, and fiduciary duties play rather a major part. Now, for those of us like me, and probably most of us here, David, over the years, because we've been friends for many decades, has told me on many occasions that equity is much preferable to the common law because it's logical and principled. Now, I don't entirely believe that, but over the years, have come to sympathise with it a bit more. Now, the fact that it is logical and principled doesn't mean it doesn't develop. It has. Last year, as David said, we got 3 Supreme Court cases on it. Which we're going to talk about. We're going to summarise the facts briefly. We're going to try and tell you about the legal principles which were decided, and then we're going to try and suggest why they're important for us, the professional liability practitioner. David, speak loudly.
Okay, so we're going to start actually with the 3rd case, which is Hopcraft and Close Brothers. And although it's the 3rd of the 3 cases, logically it ought to come first because it has a very interesting and detailed discussion about who is a fiduciary. And it's the first time that the Supreme Court has looked at this question. So let's start briefly with the facts. The claimant customers approached car dealers in order to acquire cars on hire purchase. In each case, the dealer receives a commission from the lender, which is either not disclosed at all or not properly disclosed to the borrower. The claimants sue the lenders for the amount of the commission, and the Court of Appeal upheld that claim on 3 grounds. The first ground was that the lenders were liable for dishonest assistance by assisting the dealers to receive the commission in breach of fiduciary duty. So that raised the question, who is a fiduciary? The second ground was that the lenders were liable for the tort of bribery, and that indirectly also raised a fiduciary question because the question was whether you needed to be a fiduciary in order to receive a bribe, in order for any payment to count as a bribe. And the third issue was whether the hire purchase agreements should be reopened under the Consumer Credit Act 1974 on the basis that they involved an unfair relationship. So the first ground is the one that I want to focus on today, which is whether the dealers were fiduciaries. The reason for this is that the tort of dishonest assistance means dishonest assistance in either a breach of trust or a breach of fiduciary duty. So that's why the Supreme Court needed to ask who is a fiduciary. And there are important lessons in relation to this for all of us who do professional liability work. I should say that as the same rules apply both to trustees and to other fiduciaries, we'll use the shorthand term defendant to mean a trustee or a fiduciary, and claimant to mean either the beneficiary in the case of a trust or the principal or client in the case of a fiduciary. So I'm going to hand over to Hugh.
Yes, there are several kinds of relationships which are clearly fiduciary, and we're going to go through them in a minute. The categories aren't closed, but the courts will not readily expand them. The Supreme Court said, not very helpfully, there is no bright line test. Well, I say unhelpfully, it's quite helpful for those of us who litigate about them. But they did say you're more likely to be recognised as having a fiduciary relationship if there's an incremental extension to an existing category. For us tort lawyers, that's quite helpful because that's a bit like the court's approach to novel relationships giving rise to a duty of care at common law. The essential feature of a fiduciary relationship is that the defendant is under a duty to act solely in the interest of the claimant, and I think implicit in that, does so to the exclusion of his own interest, and it's the final words which are essential. Many commercial relationships, and the Supreme Court bang on at length about commercial relationships, require the defendant to perform a service for the claimant, but most commercial relationships are not fiduciary, and we need to consider why. Now, the Supreme Court considered 5 types of relationship which clearly are fiduciary, and they're, of course, the baseline from which you then extend to novel relationships. And the paradigm case, of course, is trustee and beneficiary. In the context of professional liability, this is most likely to arise in the case, you'll know it better than we do, solicitor's client account, which of course is money held on trust. And much of the law relating to fiduciaries is based on the extension of trust law. The second category is company directors. Now, they're not literally trustees because the company's property isn't owned by them, it's owned by the company. But the directors are the ones with control over the property, and they're therefore in a fiduciary relationship towards the company, though not towards the shareholders, and that's codified in the Companies Act 2006, David.
Yeah, the third category is partners. So the fiduciary relationship between one partner and another derives from 19th century law, but it was all codified in the Partnership Act 1890. However, the basis of it is the implied duty of utmost good faith between partners. But the position may be different when it comes to LLPs, because the LLP Act of 2000 does not expressly impose any duty of utmost good faith, unlike the Partnership Act. Although I suspect what the courts will probably say is that although LLP members are not in a fiduciary relationship with each other, they are in a fiduciary relationship with the LLP itself, which is a separate legal entity, and the basis for that is likely to be agency. But the position is also different in the case of joint ventures, because the term joint venture, which is often bandied about, is not a term of art, and it can mean all sorts of things, from a partnership agreement to a simple commercial agreement. So it's actually a good example of the danger of attaching a label and assuming that all the consequences follow. The fourth category is solicitors. And as the Supreme Court pointed out in Hopcroft, this goes back to Nocturne and Lord Ashburton, House of Lords decision in 1914, where it was said, a solicitor is the fiduciary of his or her client to the extent of the solicitor's retainer and in relation to the client's funds or property which the solicitor handles. Now, that needs unpicking. The position regarding clients' funds is straightforward. As Hugh has said, they are held on trust in the client account. As regards the retainer, it seems to me that's less straightforward, because it is surely more accurate to say that a solicitor's retainer is partly fiduciary and partly commercial. Because if it were entirely fiduciary, then any solicitor would have a duty to his client to tell him to go down the road to another firm who are half the price and twice as good.
So, David, can I ask a question? This is my pre-planted question. There are some aspects of the solicitor's relationship with his client which are plainly not fiduciary. Yeah. One is negotiating fees, because of course you're on the opposite side. The second is, thankfully for all of us, you don't have to say, well, actually there's someone much better and cheaper down the road. Is that the limit? Is there anything else?
Well, I think it might go a little bit further than that, because the solicitor's terms of engagement are a commercial negotiation between the solicitor and the client. In practice, it doesn't often arise in that context because what we're usually looking at is purported exclusion clauses or other things where the solicitor isn't really taking on the responsibility that the client thinks he ought to be, or later thinks he ought to be. That's usually dealt with either by the Unfair Contract Terms Act or the Consumer Rights Act. So in practice, one doesn't usually look at the fiduciary aspects of it, but I think they are there.
Right, final category. Shall I
Yes.
do the final
Yes,
category?
please.
That's agency, which is much more difficult because not all agents are fiduciaries. And the Supreme Court said this: "It is important not to distort the commercial bargain between parties to a contract by too readily implying fiduciary obligations into a commercial relationship." And it stressed that a person may be in a fiduciary relationship, a position as regards one part of the relationship, but not in relation to another part. Now, that was obviously said in the context of agency, but the same applies obviously to solicitors, as we've just been discussing. The Supreme Court gave some limited guidance as to which agency relationships are fiduciary, and there are 3 points. Firstly, it approved Lord Justice Legate's statement in a case called El Nayahan and Kent that the relationship is likely to be fiduciary where the defendant accepts a role which requires him to exercise judgment and make discretionary decisions on behalf of the claimant and to put aside his own interests and act solely in the claimant's interests. And as an example, a discretionary fund manager is obviously in a fiduciary relationship because he has a power to make decisions which are binding on his principle. Secondly, the Supreme Court said that a contract between the parties must be considered in the totality of the context. And that's the reason why estate agents aren't fiduciaries. Now, estate agents take your house and in a nefarious way try and sell it. And what they precisely get up to, we haven't the first idea. And it's very obvious, and there's a case of the House of Laws called Kelly and Cooper that says so, that it can't be a fiduciary relationship because they're trying to sell someone else's house, which is a bit similar to yours, at the same time. And you can't later say, but he was promoting that one, not my house. So that's a very good example of looking at a relationship in its complete totality. Finally, the test is objective and does not depend on the claimant's subjective trust and confidence in the defendant. The court offered this as a reason why an electrician or plumber does not owe a fiduciary relationship, although, of course, you may depend for your life on what the electrician or plumber, most likely electrician, does to your house. I'm not quite sure why there's this prejudice against electricians or plumbers, because it looks to me a bit fiduciary. But anyway, it isn't, and it's probably because the courts are not willing to extend existing categories very much. Right, so where does this leave professionals, apart from solicitors?
Apart
David?
from solicitors,
Yes, you can
right.
tell us.
Well, in practice, the question doesn't arise that often, I have to say, because usually claims against other professionals are for negligence or fraud, as the case may be, but not if they want insurance, and not fiduciary, not for disloyalty. But it does happen from time to time, and when it does, it seems to me there are 2 approaches which the courts tend to adopt. The first approach is to look at agency law and to consider whether the principal, that the defendant is acting as an agent for the claimant. So Hugh was talking before about agents with discretionary powers to bind their principal, and that is the purest form of agency, someone who has power, authority to do something on behalf of the principal. So I've put on the slide three examples. There are many others one could choose. JP Morgan and Springwell, relationship between an investment manager and an investor might be fiduciary but wouldn't necessarily be. The Court of Appeal agreed with the trial judge, Mr. Justice Gloucester, that on the facts it was essentially a commercial banking type relationship. A CH Offshore and Internaves, more recent case, intermediary who brokered a charter party between the ship owner and the charterer, held not to be the agent for either party because he had no power to bind either party. So that was saying no discretionary powers. And therefore, he was entitled to keep the commission that he received and didn't have to disclose it. By contrast, Brandeis Brokers and Black, Mr. Justice Toulson, as he then was, the relationship between a broker on the London Metal Exchange and his client had the characteristics of an agency, even though it wasn't strictly an agency relationship, and that was enough to make it fiduciary. And then somewhat unhelpfully, the Supreme Court, in the Hopcroft case, said that barristers might sometimes be fiduciaries, but not always, but didn't tell you why. So I suppose I shouldn't be complaining. But the other approach the courts take is to draw an analogy with solicitors, where, as has been explained, the law is rather better developed. So an example of this is Bolkire and KPMG, the well-known case where it was said that an accountant who was providing litigation support was doing very much the same work as a solicitor, and therefore the same rules about conflicts of interest applied to him as would apply to a solicitor. But that brings us back to the question, does it matter? Is it either necessary or sufficient that the agent has power to bind the principal? And is that the litmus test? And the answer is it's undoubtedly a strong factor, but it's not a necessary factor. So there's another passage in the Underhyan case where Lord Justice Leggett said, I've put it on the slide, such duties may also arise where the responsibility undertaken does not directly involve making decisions, but involves the giving of advice in a context, for example, that of solicitor and client, where the advisor has a substantial degree of power over the other party's decision-making. So it seems to me that was his attempt to fit solicitors into the general pattern of agency, and he had to agree it didn't quite work because they don't have discretionary powers. I think probably the answer is it's historic, and it's been recognised since 1914 that solicitors are fiduciaries, and that no one's going to change that. But it does make it quite difficult to decide how much further the law is going to go. It also seems to me that that quote could apply equally to plumbers and electricians. But I guess the answer is that the categories have developed incrementally, and you can get from a solicitor to an accountant, but not quite so easily from a solicitor to an electrician.
To return to the facts of Hopcroft, that's a case where a buyer has a relationship with the car dealer arranges hire purchase for the buyer. It's not an established category, and the Supreme Court said it should be regarded as a purely commercial relationship. And they go through a series of facts, and I think once you read the facts, it's quite a long judgment, you can see where they're coming from. Now, it follows from that the receipt of the commission by the dealer was not a profit made in breach of fiduciary duty. And if you're not in breach of fiduciary duty, then the lender couldn't be liable for dishonest assistance in the breach of a fiduciary duty. The second part was the law of bribery, the tort of bribery. It doesn't help, of course, that the leading judgment was given by Lord Briggs, who's a chancery lawyer, and he basically treated it as a common law counterpart of an unauthorised profit paid to a fiduciary. And for the life of me, I can't see how the tort of bribery actually has any relevance to anything anymore. It's really been subsumed into equitable principles. The tort only applies when the payments are made to a fiduciary. That's the starting point. Anything wider is going to cause confusion in commercial relationships. And Lord Briggs said, well, you can deal with that by economic torts, like conspiracy and inducing breach of contract. Oh yeah, I mean, those economic torts, they're a complete minefield, if you ask me. The Supreme Court also held that where the recipient of a bribe or commission is a fiduciary, the money will be repayable unless there's full disclosure. That's just traditional equitable principles that even I know. And the Court of Appeal had held in another case that a commission was not repayable. That's a case called Medstead and Canaccord. No, it's not here. Don't worry. It was not repayable because there was a sophisticated client who knew there had been a payment and he could have asked how much the commission was, but he didn't. And very probably that is no longer good law. We now have the strict equitable principle. And we're going to look at it a bit more, I think, when it comes to Rucadzi. Finally, and the least interesting bit for us, is the Consumer Credit Act. In one case, the HP contract should be set aside. We're not interested. It's nothing to do with us, and I'll ignore it. The main takeaway for professionals, professional liability lawyers, is the discussion of the fiduciary duty, which we have attempted to summarize. So we're now going to move on to a different case.
So now we move on to the Rucadzi case, which was the first of the three. And let me summarize the facts briefly. The claimant company acted for the estate of the late Arkady Patrakatsishvili, otherwise known
well done.
Yeah, I've been to Georgia, so I can pronounce these names. Otherwise known as Badri. Any aficionados of Russian and Georgian litigation will recognize the name. So he was a Georgian billionaire who might or might not have been murdered, but that's not relevant to this point. The claimant company was retained in order to recover his assets worldwide, and the defendants were three people who were senior employees of the company, or directors of the company, one of them being a solicitor. So they were plainly in a fiduciary relationship with the claimant company. And what they did, they fell out with the claimant company. They started bad-mouthing the claimant company to the family of Badri, and they ended up nicking the business from him. And they got the business for themselves, and they made a profit out of it of $179 million. And not surprisingly, the claimant company wanted that profit back. So the trial judge held that they were fiduciaries, that was straightforward, and held that they therefore owed a duty to account for the profit, but she allowed what's called a liberal allowance. You may have come across this. It dates back to cases in the 1950s and 60s, particularly Borman and Phipps, yes, where a trustee or a company director behaves honestly, but nevertheless makes a profit he shouldn't have made. I think in Borman and Phipps, it was a director of a company that owned some shares in another company. It suited them to buy more shares to give control, but there wasn't the money available to buy the shares, so the defendant bought them himself. So it was an honest reason, but nevertheless he'd made a profit which he shouldn't have made. He was held to be a fiduciary, but the court, as a SOP, granted him what they called a liberal allowance for his time and trouble. So that was how it stood at first instance. Then it went to the Court of Appeal, and then it went up to the Supreme Court. And the issue in the Supreme Court was about the counterfactual, whether there should be a counterfactual. Because what the defendant said was, had they not been in breach of fiduciary duty, they'd have discussed this with the claimant company, and they would probably have agreed a 50-50 profit split. And therefore, that's the counterfactual that should be adopted. You compare the position that the claimant is actually in with the position the claimant would have been in if there had been no breach of fiduciary duty. And that gave rise to the counterfactual. In order to succeed on that counterfactual, they would have had to reverse Borman and Phipps and another House of Lords case called Regal, Hastings and Gulliver. And for that reason, there were 7 justices who heard the case.
Now, there are 4 judgments. Luckily, 3 agreed with Lord Briggs, so the busy or lazy practitioner, which I think is most of us, doesn't have to read the others. He upheld and restated the orthodox principle which applied to all fiduciary duties, all fiduciaries. Now, what is really quite helpful, I think, in Lord Briggs's speech is that he gives a hierarchy of the principles, and the top of the hierarchy is the duty of undivided loyalty. And following from the duty of undivided loyalty, which a fiduciary owes to his principal, we get to the next layer down, which is 2 freestanding duties. There's the no conflict rule, and there's the no profit rule. And you'll be familiar with Lord Justice Millett's statement in Bristol and Mothew, and if you're not, it's all set out in Jackson and Powell, which says it's mostly about the no conflict rule. Now, these two freestanding primary duties mean that if there's a breach of either of them, and it's really going to have to be a breach of at least the no profit rule, what has been obtained by the fiduciary belongs in equity to the claimant from the outset, unless the claimant has given his informed consent, and the informed consent has to be pretty full, as we know. Lord Briggs described the rules both prophylactic and deterrent. The primary reason is human frailty. It may lead a defendant to prefer his own interest to that of his principal. Further, we have the deterrent effect of ensuring that the fiduciaries don't deviate from their duty of undivided loyalty. This comes up, I think, most obviously in the case of agents. Where an agent is dealing on behalf of the principal, but because he's dealing with it, the principal doesn't really know what he's up to. And therefore, it's imperfectly observable what the fiduciary has actually been doing. And therefore, the fiduciary can ask for the odd bribe and that sort of thing, prefer his own interest. Lord Briggs stressed the importance of this principle in relation to, in particular, solicitors. David.
Yeah, I want to focus now on one paragraph in Lord Briggs's judgment, because I've read a number of commentaries, learned articles on it, which criticise Briggs, and I don't think they've really focused on this paragraph. He says the term account of profits can be used in two quite different ways. Firstly, there is the primary right of the claimant to the profits made in breach of fiduciary duties, and that is a freestanding right. And of course, the correlative obligation is the duty of the defendant to account for those profits. That's in terms of rights and duties. The second is in terms of remedies. The equitable remedy of an account for profits is the means by which the right is specifically enforced. So when it comes to the remedy stage, equitable principles kick in, and there is room for refusing a remedy in much the same way as the court can refuse a remedy for specific performance in relation to breach of contract. So the remedy of an account is fundamentally different from the remedy of damages, because an award of damages is, for negligence, say, or breach of contract, is obviously compensation for loss, loss caused by the wrongdoing, and therefore it requires a counterfactual. We all know that, the counterfactual being what would have happened if there'd been no tort or no breach of contract. The same has been held to apply in relation to equitable compensation for breach of fiduciary duty or breach of trust, which is also a form of compensation, and you'll be familiar with the cases of Target and Redfern and AIB and Redler, and they all say that you have to have a counterfactual, and they are borrowing principles of the common law because it's loss-based. By contrast, an account of profits is gain-based. So the required link is between the fiduciary duty that is owed and the profit that's been made in breach of that duty. And that link needs to be established in order for an account of profits to be ordered, but that is all that needs to be linked, all that needs to be established. There is no need for any kind of counterfactual. Once you've established your right, there's no room for the counterfactual, and that's why Lord Briggs described the two kinds of remedies, gain-based and loss-based, as being like chalk and cheese. So the defendant, as I said, argued that if there'd been no breach of fiduciary duty, the parties would probably have agreed a 50-50 split of profits, and that was the counterfactual that they sought to introduce into the Supreme Court.
Lord Briggs distilled the following test. Is it coming up? Yes, it is. The question is not would the profit have been made even if there had been no antecedent breach of fiduciary duty, but did the profit owe its existence to a significant extent to the application by the fiduciary of property, information, or some other advantage which he enjoyed as a result of his fiduciary position, or from some activity undertaken while he remained a fiduciary duty, which the conflict duty required him to avoid altogether. For that purpose, the court looks closely at the facts, i.e. what actually did happen, but does not concern itself with what might have happened in a hypothetical but-for situation which did not in fact occur. In other words, there has to be a link between the breach of fiduciary duty and the profit, and Lord Briggs explained it in this way. I don't know if this is his personal predilection. A company director who wins money by betting on a horse outside working hours is not liable, generally, to account for the winnings, unless he acquired inside information about the horse through his work. And if he has, merely resigning his position is not going to do any good. You can't resign your position and then make a profit because you'll still be in breach of a continuing fiduciary duty. David, the test. Was the profit to a significant extent derived from the property or opportunity which was subject to a breach of fiduciary duty? Is that an adequate test, or has Lord Briggs nodded?
I think it's plainly not an adequate test. I think that the phrase is a recipe for further litigation and is really unclear. It's unclear what it means, which is great for us who do litigation. I prefer Lord Burroughs' test. He gave a concurring judgment, getting there by a slightly different route. But the phrase he used was all unauthorised profits obtained by reason of and out of the position of a fiduciary. I think that's probably what Lord Briggs is trying to say, but it does say it rather more clearly.
I think he is, because if you look at all the paragraphs before, he goes through all the cases which are very specific about their tests, and then there are some which are a bit more general before he comes to...
Absolutely, but I think certainly at first instance, and possibly even in the Court of Appeal, there's room for argument as to what Lord Briggs meant. I'm
sorry, I interrupted.
Yeah,
that was not a pre-programmed
I should say that there's an easy solution for any potential defendant who wants to avoid trouble, and that is to make full disclosure. And that full disclosure means really full disclosure, because that's the only defence to a claim for breach of fiduciary duty for an account of profits. But one issue that remains not fully resolved by the Supreme Court is the liberal allowance, which I talked about before. So the trial judge allowed a liberal allowance of 25% of the profit to compensate for the time and trouble in doing the work. And as I said before, on the alleged counterfactual, it would have been a 50-50 split. So although it's called liberal, it's actually an awful lot less than what they would otherwise have earned. But what the Supreme Court said, Lord Briggs said, I should say, there was no permission to appeal on this point to the Supreme Court, and therefore they weren't really required to consider it, but they did say a few words about it. And Lord Briggs said, the deterrent effect of the profit rule is all the more effective if the fiduciary, tempted to stray into a conflict situation, knows or is advised that any account of all his profit is a virtual certainty, but the amelioration of an equitable allowance is only a judicial option and subject to a high degree of uncertainty in amount. Thus, the equitable allowance is, as a matter of policy, deliberately vague. So that seems to be the upshot of it. Perhaps the best way of understanding how the liberal allowance fits in is to go back to the difference between rights and remedies, which I mentioned before. The claimant has a right to the entire profit because the profit was earned in breach of fiduciary duty. But when he comes to enforce his remedy, equity may allow the liberal allowance in much the same way as, say, in relation to specific performance. Equity might refuse on the ground of unreasonable delay or some other ground. So that's a look at Ricadzi from the aspect of professional liability practitioners, and the main relevance of the case to us, I think, lies in the restatement of the no profit and no conflict rules as being primary rules which are related but separate from each other, and also the lack of any counterfactual and the causation test.
We finally turn to Hotel Portfolio 2, which has the most entertaining facts of the three, and cases we're looking at, and also involves a dishonest solicitor. The claimant company sold 3 hotels for market value to Cambulo, a company ostensibly owned by the dishonest solicitor, Mr. Stevens. Mr. Stevens was a nominee for one Mr. Ruhan, who was the director of the claimant. This meant that the sale to Cambulo was a breach by Mr. Ruhan of his self-dealing rule, and hence that Mr. Ruhan was liable to account for any profits later made out of the hotels, even though they'd been sold at market value. What happened is that Cambulo developed the hotels. I think they got planning permission to turn them into expensive flats, and sold them at a large profit. Cambulo distributed the profit by way of dividend. Stevens procured the payment of over £100 million profit to Mr. Ruhan. Mr. Ruhan then dissipated the assets. Mr. Ruhan committed 2 breaches of trust or fiduciary duty. The first breach of trust was in buying the hotel through Cambulo and then failing to account for the money, the profit he made on the sale. And the claimant, very sensibly, elected to claim an account of those profits. It didn't want to claim its loss because it hadn't suffered any loss because it had sold the hotels at market value. Now, having elected to claim an account of those profits, they were held on constructive trust for the claimant. The second breach of trust was dissipating those profits. The trial judge held that Mr. Stevens had dishonestly assisted Ruhan in both breaches of trust and was liable to compensate the claimant. Mr. Ruhan did not appeal, I think because he had managed to dissipate £100 million. And I don't know really quite how you do that. Is anyone else apart from me old enough to remember the famous Northern Irish footballer of George Best? Yeah, George Best. George Best is a great man, very charismatic, extremely good footballer, very well paid, but he lived a rather rackety existence and spent all his money and went bankrupt. And he was asked, I'm afraid he later died of liver cancer. I mean, but he was asked, well, George, what's happened to all the money? And he said, well, I spent most of it on wine, women and song, but the rest I wasted. I have a lot of sympathy for that, but how you managed to get rid of £100 million, I don't know. I'm sorry, that was a digression. David?
Yes. So, coming back to the law, Stevens appealed, and the matter went to the Court of Appeal, and they decided in his favour on 3 grounds, and they were all wrong. So what it shows is when the Court of Appeal gets it wrong, it can often get it wrong in a very big way. Firstly, they said that Stevens had dishonestly assisted Ruhan, absolutely right, to commit both breaches of trust, but the 2 breaches could not be separated. It was really all one big breach. Then they said that the relevant counterfactual was that neither of the breaches had occurred. And if neither breach had occurred, the profit would never have been made in the first place, nor would it have been lost. Therefore, there was no loss. And thirdly, they applied the well-known principle, actually it's an equitable principle, but applied in common law of set-off of gains against losses, and so that they were sufficiently connected, which meant that the gain that was made by selling the hotel at a profit was set off against the loss that was made by dissipating the money. So that was the Court of Appeal's approach. Let's turn now to, but that sets the scene for the task which faced the Supreme Court. What the Supreme Court did was they reversed the Court of Appeal on all 3 grounds. Firstly, they said an unauthorised profit made in breach of trust is automatically held on constructive trust for the claimant. English law does not recognise remedial constructive trusts. In other words, unlike, say, American law, the courts won't impose a constructive trust as a way of granting a remedy, a proprietary remedy, but you could only have a constructive trust if, as a matter of law, the money really does belong to the claimant. So the remedy for any breach of trust, whether it's express or constructive, is which results in an unauthorised profit, is either a claim for the profit, gain-based remedy, or a claim for the loss caused by acting in breach of trust. And in most cases, the 2 add up to the same thing, although conceptually they're different. But as Hugh says, the claimants elected, because of course you have a choice between the two remedies, you make an election, and they elected to claim the loss of profits from Ruhan. So, Ruhan, having therefore held those profits on a constructive trust for the claimant. So now you've got a trust established with Ruhan holding property on trust for the claimant. But as we know, the wrongdoing didn't stop there, because there was then the second breach of trust in dissipating those profits. And that was a breach of trust which Ruhan was able to commit because of Stephen's assistance in handing the money over to him. So that second breach of trust gave rise to either an account of profits or, well, in fact, there were no profits, it was lost, but it gave rise to a claim for compensation for the loss. And they were two quite separate things. So, moving on, the rule is a person who dishonestly assists in committing a breach of trust or breach of fiduciary duty is liable for the loss caused by the breach. They are not liable for the profit. They're not liable for an account of profits, which is gain-based, unless they've received the gain themselves.
And poor man, he only got 1.5 million, didn't he?
That was his cut. So to that extent, there's a gain. But as for the rest, it's simply a loss. And that meant Stephens could not be required to account for the gain made by Ruhan, but he could be required to account for the loss caused by Ruhan's breach of trust. And as Target and Redfern's and AIB and Redler make clear, a counterfactual applies if the claim is for loss rather than profit. But it's important to get the right counterfactual. So what the Court of Appeal did was to roll the two breaches together and make it a single counterfactual, but they are, properly analysed, quite separate breaches. And it would be bizarre to find in favour of a person who is in breach of trust or someone who's dishonestly assisting them, that you could run together two separate breaches in order to prevent there being any loss. The right counterfactual was simply to say what would have happened if the second breach of trust had not occurred. You can forget about the first one. It's water under the bridge, because by the time you get there, he's already made that profit and is liable to hold it as trustee. So the relevant counterfactual was that Ruhan did not commit a breach of trust in dissipating the profit, which was a trust asset, and there was no need to go any further. And that brings us to the final issue, which was the set-off.
The set-off, yes, it doesn't apply to breaches of trust. The defendant, of course, said he could set off the gains against the losses, and Lord Briggs said, it's Lord Briggs again, he had a busy year last year, didn't he? That was seeking to rely on your own dishonesty, your own fraud, to ravel rather than unravel all. The correct position is that any profits made through a breach of trust are held on trust for the claimant and should normally not be set off against each other. There's a very narrow exception, which applies in the case of fiduciaries, where you can set off gains and losses, where it will be inexorable otherwise to do so. The primary case on this is one 45 years old called Bartlett and Barclays Bank, where the defendant's negligent failure to review investments resulted in both gains and losses. What Barclays Bank had managed to do is they had a lot of money belonging to the claimant, or probably his, I think it's probably the estate, but originally to the deceased. And for 40 years, they had held his money and not done anything with it at all. They had simply never reviewed it. I mean, it's quite extraordinary, but it's not surprising in facts like that you actually look at all the gains and losses, because some of the things they'd never reviewed had done really well, and some had done atrociously badly. So you had to look at the whole lot against what would have happened if they were properly invested. But that's a really very narrow exception. It's worth noting, I think I've said it before, that Mr. Stephens was a solicitor. Now, looking at friends and colleagues in this room, I can confidently say that very few of us lawyers are dishonest. We belong to a very honest profession. But luckily, for those of us who litigate, there are one or two of our members who are bad apples, and they cause an enormous amount of litigation. Isn't it fun? Two examples of the last few years involve solicitors. There's Twinsectra and Yardley, which reads the House of Lords, and then Group 7 and Nazir, which didn't get quite that far, but was even more complicated. And of course, now we've got Hotel Portfolio 2. And the main relevance of Hotel Portfolio 2 for us professional liability practitioners is that it is important to work out whether any counterfactual applies, and if so, to apply the right counterfactual. Absolutely. Have we finished?
We have, except that I have to add this. I don't like the reference to Bartlett and Barclays Bank being 45 years old, because I was in pupillage at the time. My pupil master was in the case. But there we are. We have time for a few questions. No, we don't.
We don't have time for questions. It's just, well, because none of you are going to ask any, were you?
Well, if anyone would like to, we'll be around at lunchtime and very happy to take questions. Thank you.
Right. That was all right, wasn't it?